Before I get into the questions, it looks like we have about 22 questions right now. I just hope that everybody has a great 2026 in your association. Remember to reach out to your trusted advisors when difficulties arise in 2026. One of the things that our firm does that I think is really helpful for associations is we practice preventative legal. And what that means is we encourage our clients to address problems early in the process. Don't wait and let it fester where it becomes a huge problem and now it's going to cost a ton of money to fix. It'd be better to talk about it with your legal counsel early in the process to prevent the problem or to determine a strategy to, resolve the problem quickly. One thing that we do as a firm is that every single day, a business day, that the courts are open, we get a summary of all the lawsuits that are filed in Arizona that day. At the end of the day, they send it out at about 5:05 p.m. every day. And I have one person in my office that all they do is give me a listing of every case filed against an HOA or condo in Arizona every day. And I want you to hear it from me that my goal is to not have any of my clients on that list. I do not want my clients being sued. And what I can tell you is, and my team member that handles this for me, Cled, very rarely, like a handful of times a year. And remember, we have 1,000+ clients. Will I see one of the clients that we are the attorney for sued in a fiscal year? And I see every day, just so you know what's going on out there, is every day there's 2 or 3 new lawsuits being filed against associations. So what we're suggesting works, okay? Being preventative, proactive on the front end of a problem versus waiting until it festers and it becomes, this huge World War III type of thing. So I really encourage you, if you're listening to this seminar today, be proactive and practice preventative legal. It's going to save your association a lot of money. It's going to save your association a lot of headaches, and it's going to make your association run more efficiently and get things done in 2026. Okay, let's hop right into our questions. Our first question is, we had to condense it a little bit. It's from an owner who is currently running for the board. The question is, we have our election scheduled for January 21st. And several other candidates and I have serious concerns about the election process. The management company we have uses significant negative online feedback, including comments suggesting potential legal action, and they've made several critical mistakes during this year's election that have been dismissed as minor oversights. While our current board does not view these issues as problematic, it is unclear whether the errors were intentional or were they mistakes. And we are concerned about whether the election will be handled professionally and accurately. For example, how can we ensure that all mailed or emailed ballots are properly accounted for on election day? And would it be prudent to involve legal counsel before the election, or wait and see how it is handled and seek counsel only if concerns arise? So great question. You're a homeowner, you want to get on the board. There have been a couple of mistakes on your annual meeting. From your perspective already, I think the best advice I can give you is you should hire legal counsel to oversee this with you. And if you contact our office, we can give you the names of several attorneys who represent homeowners in situations like this. I think that's really the only way to ensure that you get a fair shake as candidate. And I think knowing that you have an attorney and you can tell the board and the management company this, I think they're going to be held to the highest possible standards. So, things will be handled properly in my experience. Okay, question number 2. We had to condense this question as well. Our association has decided to proceed with attempting to create a third amendment to our CC&Rs. The last amendment was 25 years ago. Given the amendment deadline to amend is August 11th, 2026, based upon the language in our documents, and our documents require 75% owner approval, our attorney has advised us that 100% approval may now be required and that the 75% provision is obsolete. Can you clarify the correct approval threshold and whether DocuSign may be used by the 120 lot owners for the initial ballot, or if U.S. mail is required. Okay, hard for me to comment on this because I don't know what your CC&Rs say. I don't have the exact section. I have to see that section in order to give you advice specifically on it. Some just general tips I can give you on this would be read the amendment provision carefully. I think I would get a second opinion on the 100% because that doesn't sound right. I don't know what sections you're amending. I don't know the exact language, but there may be a way to, handle the amendment, without getting 100% approval. Typically, we look at what do the CC&Rs require, right? The exact actual language. There is a case called the Callaway case, which maybe your attorney is thinking about, that, does talk about the amendments need to be foreseeable and reasonable. And if they're not, then you may need to get 100% approval. But the scope of that is very limited. So I would have to hear more about, what your association is considering to amend and see the actual language in your documents. So short answer to your question, best advice I can give you is get a second opinion. And I do think that 100% sounds like a little bit overkill. I'd have to see the language just to give you my own opinion on that. But can you use DocuSign? It depends on what the language is. Depends if you have to have the documents notarized. I don't think DocuSign is the equivalent of having the documents be notarized if your amendment provision requires them to be notarized. So I have to kind of see everything, the totality of everything, to help you make the best decision on that. Okay, question 3. From an owner, we had a records request submitted on 12/11 before the contract was ending with the property management firm. About a third of the documents were provided on 1/1/2026, the date to which I agreed to due to holiday office closures, and the manager then refused to send the remaining documents. Senior manager also advised to send the request to the new property management firm. Is the old property manager correct and absolved of providing the documents? Are there other options besides requests sent to the new property manager? So unfortunately, you got caught in the crosshairs of a change in management company. Ultimately, the association is responsible to provide you with those records. So I think the best and unprofessional for the old management company to not just take care of it before the transition, but I don't know their side of the story. I'd probably have to hear that before I can make that final conclusion. The best advice I can give you is contact the new management company, explain what happened, ask for the records that you haven't received, and go from there. Next question is from an owner. The association is dealing with 2 owners, one of whom is a former board member, who are acting in concert and pursuing architectural modifications that do not comply with the governing documents. When the association denies these requests or requires corrective action, both owners respond with threatening correspondence, prompting the board to apply or seek legal counsel. As a result, the association's legal expenses for 2025 exceeded the budgeted amount. The CC&Rs provide that the association may recover all enforcement costs, including attorney's fees, from owners whose noncompliance requires enforcement, whether or not litigation is filed. Given these circumstances, what mechanisms are available to the association to recover these legal fees from the homeowner whose noncompliance necessitated the enforcement action? Okay, you're an owner, you're upset about 2 other owners who are apparently violating the association's documents by making changes, without getting architectural approval. Based upon what you're telling me about the language in the CC&Rs, the association's attorney should be contacting the, offending violators and asking them to pay the attorney's fees. But I have to look at the language before I would definitively send a letter like that, because it's unusual that the CC&Rs say, that you can just add attorney's fees to an owner's ledger for violations. It's not, that's not possible, but it's unusual. More likely than not, it says that the prevailing party is entitled to their attorney's fees, and that, implies that you have to have litigation and a judge to, enter a judgment for the attorney's fees. So short answer is I need to look at your documents, but based upon what you're providing to me, it does look like the board does have the authority to do that, and the attorney for the association should be sending a letter to the owners to request this. Now, because you're an owner, you may not be aware that that is already happening. Okay, question number 5. Which holidays do the majority of HOAs allow residents to decorate their home with lights and or yard decorations? Ooh, that's a good question. I would say most associations don't get too keyed up about this because nobody goes too over the top. And so, a majority of the HOAs allow, whatever holidays that people, want to decorate their homes for, and it's not an issue in my experience. Okay, question number 6. We are trying to find a new insurance carrier, and it appears they do not want to offer umbrella policies anymore. Is this the trend? Not necessarily. That would be a good question. I have not heard that from any of our clients, and we get insurance questions every week. What I am hearing is that the premiums are significantly higher, and that some associations are just having their insurance policies canceled altogether. Maybe the insurance carriers that you're reaching don't offer umbrella policies. I would talk to your insurance agent and ask for, why this is occurring and ask for suggestions in terms of how, you should handle this if you want to obtain an additional umbrella policy on top of what your coverage already is for your association. Okay, question number 7. Is an annual compilation necessary for our community? So great question. This deals with financial and accounting controls for an association, checks and balances. So under Arizona law, and this applies to both condominiums and to planned communities, an association is required to conduct an audit, a review, or compilation every year. If your documents require an audit to be done by a CPA, and typically you'd find that in your bylaws, then the audit must be done by the CPA. Your question is, do we have to, do an annual compilation? Well, short answer would be yes. You have to do every association that's a condo or planned community in Arizona has to do an audit, review, or compilation every year. It's not a requirement that you do a compilation, but you have to do one of the 3 things every year. Audit, review, or compilation. Okay, question number 8. Does the HOA board have to reference what CC&R a violation the homeowner is violating? If they cannot reference a CC&R violation, is the violation invalid? Oh, that's kind of a trick question. Best practices is that when you're sending a violation letter to an owner, that you should be very specific about the behavior and which section is being violated. And also there are some provisions under Arizona law that also require for you to indicate the provision in the documents when you're sending a violation letter. Now, that being said, some, provisions in the documents are kind of open-ended, like nuisance, if somebody's creating a nuisance. So, if, you've got a dog barking or you've got loud music or parties or somebody that's having a DEA SWAT team coming in, that might not be specifically addressed in your CC&Rs, but it would fall under the general category of a nuisance. So best practices, of course, would be for the board to indicate which section in the CC&Rs, is being violated when they send out a violation letter. If they send out a violation letter without a reference to the CC&Rs, is it considered invalid? Probably not, but probably a clarification letter needs to be sent by the association if you're asking for clarification. Okay, next question, number 9. Why would a management company want to restrict access to HOA records? So, great question. They shouldn't. The only thing that I can honestly say from being in the trenches is, records requests by owners are kind of a pain for management companies. And it's a pain for board members to comply with, especially the really large records requests, thousands and thousands of pages of documents. And typically, in my experience, they are filed by or requested by somebody that's disgruntled or unhappy, or maybe even a difficult owner. Not always, but, more likely than not in my experience. So why would they want to restrict it? It may be time consuming. Maybe they don't want, certain information to be distributed to owners. I don't know why, but sometimes, maybe they don't want, the entire community to know that the board's really over budget on something. I don't know. What the reality is most management companies do not think about any of that. And they are just going to give you the records when you request them in a timely and efficient manner. So if you have a management company that's kind of being difficult like this is not the norm. It's not in compliance with Arizona law. And there's some red flags there, and that shouldn't be happening. Okay, question number 10. Unfortunately, I see the management company adding new charges to deploy or apply AI technology. Is this something you would expect? I'm to give me an exact example on that. I mean, if anything, I think it should be like, they're adding efficiencies with the AI. So basically they should be, spending less time on tasks because of that. So I'd be curious, maybe they're charging you for AI technology to transcribe your minutes or something like that. I don't know. You didn't give me a specific example. Remember that any new charges would need to be in your management contract. So, if they are charging for something like that, I would recommend that you go back to your management contract, see if that's something they can do. Maybe it's an option that they're offering. And if you want that option, you have to pay more. Then that would probably have to be, incorporated into your management contract, depending on, if it's something that would need to be in writing. This is the first time I've gotten this question, but I haven't taught a lot of AI technology classes, so I'm very interested that that's feedback. That's why I like teaching these classes, because it kind of keeps me on the cutting edge as to what the management companies are doing. I would say it's unusual. That would be my comment, to hear that. And I'd be curious what specifically they're charging you more for. And my first comment would be check the contract to see if they can do that without your approval. Okay, next question, number 11. Our board suspects that one of our homeowners is renting out individual rooms. Our CC&Rs do not allow this. How can we lawfully find out if this is happening? So I guess where are you getting your information from would be my question. How reliable? If it's reliable, the board can send a letter, and it doesn't have to, say like violation letter. It could say, we received some information that you may be doing this, and then provide them where you received it. And we wanted to remind you that this is against, the association's documents. Please respond and let us know what's going on here, and see what the response is. Now, if you have something really specific, like just recently, I had the same issue with an association, and they provided me with the online advertisement, on it. So it clearly showed that they were renting out a room. That was very easy. We just attached that to our violation letter to the owner. Okay, question number 12. Should homeowners be a part of the strategic planning session for our board in 2026? So short answer is, anytime a quorum of your board is meeting to discuss association business, which doing a strategic plan is clearly going to be association business, it needs to be an open board meeting. So homeowners should be allowed to be there. The homeowners are not allowed to comment unless the board is taking formal action on something, voting on something. So, if a quorum of the board is there, yes. If they're talking about strategic planning, yes. Quorum of the board there, it should be an open session. It doesn't mean that the homeowners can contribute. They only can contribute if the board's taking formal action on something. Okay, next question. What platform or vendor do you feel provides the best storage, access, and security of HOA documents for homeowners to access, and is a reasonable cost for small HOAs? I'm probably not the best person to ask about that. I know that Microsoft has a great platform, and the pilot AI part of Microsoft is, very helpful in terms of searching the documents that you have on the cloud. There's so many different opportunities, that are out there now. You probably would want to bring in a technology expert and not a legal expert to help you with that. The only one that I'm aware of that a lot of our clients are using is Microsoft. You might want to look into that. And also put this question in AI and see what pops out, right? There probably are a lot of different technologies out there that you might want to research and look into. One thing I would say, just a cautionary thing, is make sure that if you are downloading stuff on an online platform, just make sure that it's a reputable company that's going to be here forever and that it's being, sent to the cloud so that, company goes out of business or whatever, you have access to all of your information. Okay, next question, number 14. What if the community has started to choose to hold the meeting in person, but rather are doing the meeting on Zoom and are requiring that the votes be in by noon on the date of the meeting? What does the statute say that they have to allow for a vote in person? Okay, so you're having the meeting on Zoom for your association. I'm assuming this is an annual meeting. And they ask that the votes be in by noon on the day of the meeting. The question is, do we still have to allow people to vote in person at the meeting? And the short answer on that is yes. Okay, question 15. Can you place a security camera at the hot tub area? I think it's no different than the pool area. I have no problem with security cameras in common area pools and hot tub areas. Question number 16, who monitors the security cameras? I kind of briefly talked about that. There's different ways that you can handle it. Maybe you have a security detail for your association if you're a large association. Board member, management company, those are the typical, people that have access to the film. But if it's not being monitored 24/7 by a security crew, which I'm guessing for most of you is not fiscally possible, you have to, when your signage should say something along the lines of, hey, this security camera is not, or this camera is not monitored 24 hours a day. If you're lucky enough to have a large association where you have a security team that's, available and monitoring it 24/7, that's kind of a rarity. I think that answers your question. Number 17, if security cameras are used, can they include audio? It depends on what kind of security system that you have, and what you purchase. So yes, if that's something that your board wants, you can do that. In my experience, that is not something that most HOAs and condos right now in Arizona have, probably because of the cost. Okay, question number 18. I'm just doing a quick little question check to see how many we have. We have 24 questions. Okay, question number 18 is, our development has signs that say the area is being recorded, but it is not. The signs are on a few of our roads placed there by prior HOA boards years ago. Are these signs legal or should they be removed? If it's misstating, the cameras, anything about cameras, I think they should be removed. Okay, question number 19. Can the HOA go after the individual that did the fraudulent check washing? Yes, if you can determine, who that person is. Like the example I gave you today, from my association, the payee individual that, washed the check, the money was deposited into their account and, immediately the money was gone and they closed the account. So these people they're pros, they're criminals. So yes, if you can determine who the person is, you can file a police report, and see if the police will do anything on it. I'm not sure that, you're going to be able to go after them to get the money because lots of time they're using, aliases, etc. You want to be smart on how you handle it, depending on how much it's been check washed. And if it happens to you once, just don't let it happen again, right? There's somebody had access to those checks and, you want to be mindful of how do you proceed going forward. You implement the positive play system. If you're using checks, make sure you're using the new checks that don't allow check washing, etc. Okay, question number 20. Do you see any issues with common area Wi-Fi? No, I don't, but I think you should have one of those messages like you have at a hotel or a restaurant that people click, if they want to have access to, the common area Wi-Fi. So you're going to need to set it up similarly to limit your liability as like a hotel would do. But most associations, in my experience, do not have common area Wi-Fi unless it's like a really large association with a lot of amenities, and they have the infrastructure in place to have one of those, warnings in place so that we have no liability if, somebody is on the common area Wi-Fi and if something happens, information is, seen by other people or shared or whatever. Okay, question number 21. Parking enforcement is a vicious cycle with no certainty of matching vehicles with homeowners. Running plates is costly and temporary. The obvious solution is having homeowners provide their vehicle information to the board or management company. Why isn't this done? Well, a couple thoughts on this. It's probably not done because it's a hassle for your association to keep all the information updated. How our association does it is we have a decal that each, association member that has a vehicle gets each year. And in order to get the decal, you have to provide your, license plate and vehicle description. And so that's one way to handle it. A lot of associations don't have the infrastructure or the ability, because a lot of times it's run by volunteer board members, or maybe the management company isn't full time for just your association. And so it might be too onerous to do this for an association. So I think the difficulty in getting this information is typically why it's not done. In my experience, running plates is not that costly. I think our firm works with our process server to do it, and it's less than $30 to run a plate. So for a violation of somebody parking on the street, and we really have no issues with pinpointing who the vehicle is. And usually the neighbors are very willing to tell you whose vehicle it is as well, because they don't want them parking on the street. So there may be some suggestions for you on how you can handle parking violations. Also, there's 24-hour companies that come in and do parking sweeps and, use of, a sticker on the car, on the driver's side window, telling them that there's no parking, or booting cars, or some, different, things that you can do for an association to get parking compliance. Okay, number 22, we had a large insurance premium increase. Our condo is in Sun City. We had the owners vote if we want to change from a condo to a townhouse. We agreed. All owners changed from H06 to H03, and it allowed us to be able to paint and do some additional capital improvements this year. Okay, I don't see a question there. I think that's just sharing information. The next question is, we have an owner that has installed a barrier to the fence that goes against CC&R or on uniformity. She claims a disability and needs this to keep her dog in the area. The HOA is allowing the barrier, but wants something to comply with uniformity. Can we require that? So if I had to guess, the barrier maybe is like it's open air fence, and maybe they put up like some chicken wire or something. Yes, I think it's reasonable just to do, like some minor tweaking so that it complies with uniformity, whether it's painting or something like that. I think that's fine. Hopefully you can come to a resolution with that particular owner so that can be accomplished. Question number 24. I think this might be our last question. It is. Okay, 24. Our insurance company has canceled our condo insurance due to seeing some owners doing short-term rentals on VRBO Airbnb. Now we need to find another insurance company. Our CC&Rs state that all rentals must be more than 5 months by owners, which is not being completed by a number of owners. What can we do to these owners? First, I'm kind of surprised that the insurance company would even have knowledge of that, the short-term rentals. So I'm kind of skeptical on the fact that it was canceled because of that. Maybe I'm skeptical on that. Okay, so how do we handle owners who are violating the rental restrictions? I would encourage you to take a look at our cheat sheet on rental restrictions. We have some good information in there on the different type of information you can require from owners regarding rentals. We also talk about some enforcement provisions. So here's what I recommend. Pinpoint the owners that are violating your CC&Rs. And you probably know already because, you're hearing complaints about it, or maybe you found it online on VRBO or Airbnb, their rental ad. And I would just have your attorney send them a letter and indicate that, we have evidence that you have violated our, rental provision, language in our CC&Rs, and levy a fine. Another kind of creative tactic would be to contact the short-term rental companies in writing to their legal department and let them know that, hey, these ads violate the CC&Rs, these associations, and you should only allow ads, to run or that indicate that this unit can only be rented for more than 5 months. That has been a successful way to, force the owners to only put advertisements out there that are consistent with what your CC&Rs say. We have a couple teaching opportunities coming up in the next few weeks that I want to make sure you're aware of. We're teaching class at Scottsdale Neighborhood College on January 29th, 2026. So next week from 1 to 3 p.m. at Mustang Library. It's in person. I will be teaching the class. So I hope that you will join us. If you want more information on the class or you want to register, you can go to our website at mulcahylawfirm.com. Also, our next First Fridays is going to be the first Friday in February, February 6th, 2026. At 9 a.m., we hop on Zoom and Facebook Live and answer questions that all of you have regarding your HOAs or condos. You can find out more information on that, submit a question on our website as well at mulcahylawfirm.com. And also all of our seminars that we are going to be teaching in January, February, March, April, May, and June are all listed on our website now. So you can take a look at the topics. We put a lot of thought into topics as to how we can best help associations and owners and managers and board members do your jobs so that it's very stress-free and, doesn't take a huge amount of your time. We put a lot of thought into the classes on what topics would be most beneficial to all of you. So I hope you will check that out and join us for future classes. I wish every association all the best in 2026. If you have any questions throughout this time this year, please always consider contacting our firm. We're happy to help you solve your legal problems, strategize with you, practice preventative legal, so that you have very few hassles on your time serving as a board member or as an owner in your association. So take care, everybody. Have a great 2026.